I'm afraid we will have to have a pause. One of the screens here is not working.
There we are.
Right. Yes, Mr. Rowe.
My Lord, the questions I was asked, or the things I promised to have a look at over the short adjournment. First of all, Lord Briggs's question about whether there was any provision in the rules, I think I answered the question correctly, allowing the authority to charge fees as part of the structure of a permit. I agree there doesn't appear to be anything expressly to that effect. I do note, however, that the word which is used on page 1082, which is in the rules concerning what the authority can do, is including.
Yes, you couldn't impose a charge without specific statutory authority.
The authority may establish in each permit conditions as required in the case of each facility, including the following requirements.
Yeah.
So you'd have to,
But it's well established that to impose a fee or charge, you need such authority.
I agree. As a general principle, I suppose you'd have to say that it was somehow justified by reference to the policy or something. But apart from that,
I think this doesn't sound your strongest.
No, I'm not making it as a point. I'm just answering Lord Briggs's question.
Right.
It's no part of my submission at all that anyone should do that. The other question I think was about the fund. 1053, I think, may provide something of an answer to that, but not much. What's the fund's money used from? This doesn't really answer any factual questions about what it is used for. It's just reminding your lordships about what the Act says. 78 contributions may be designated for various projects, and the trustees are authorised to pay for any of the following matters out of the general resources of the fund. And letter D, any other expenses which are lawfully related to the activities of the authority.
No, I was surprised because one would have thought the fund was quite an important part of the national environment policy, so one might have expected something about it.
Yes.
Now, maybe Mr. Hussain can help us.
Yes.
Is the authority funded to any extent by the fund?
Yes, it says operating expenses. 78.
78.
Yes, I think
I'm presuming elsewhere the authority have powers to correct environmental damage.
Yes.
Well, I think that must be right. Yes.
Yes, fund the 72.
72
Yeah.
authorised under this Act, including.
Yeah.
Yeah.
So, my Lord, I was just dealing with my submission that deals with what I submit is really the central proposition in the appellant's case. I'll come back to deal with the point about the alleged failure to take, or the alleged relevance of the failure to take the programme into account. But the central thrust of the case, indeed this is the way that the case is drafted as ends, is the proposition that the decision of the Minister to charge a flat fee for a water pollution permit be quashed as being contrary to the NEP is what I want to just finish off dealing with briefly now. Your Lordships, I think, have my submission essentially that so far as the broader parts of the policy are concerned, it's plainly within it. So far as correcting environmental damage is concerned, one can see the argument that that is very prescriptive and requires the charges to be used to be taken and used to correct environmental damage. But in my submission, that is too prescriptive. As I've already said, my submission is that by the very process of enabling the scheme to operate, which requires people who want to carry on polluting to pay a fee, and will therefore stop some of them from carrying on polluting because they won't want to pay the fee, they'll just stop doing it.
Mr. Rowe, when you say that the policy for money collected to be used to correct environmental damage, don't read it too prescriptively. Are we assisted in deciding how to read it by the programme, and in particular on page 1288 by 64281 in the introduction, where, as you will remember, it says that certain basic parameters were established, and the fourth alleged basic parameter is permitting fees should not only reflect the cost of granting the permit, but also the impact on the environment. What do you say about that? Is it a basic parameter?
I'm sorry, well, I didn't pick up your Lordship's reference.
1288.
Your Lordship's reading from the...
I'm reading from the
Electronic
programme.
bundle. Electronic bundle 1288.
Sorry, my Lord.
Tab 10.
That's in the programme, policy. Programme.
Sorry, Mr. Rowe.
No, not at all, my Lord. It's only that I think I had a different version of the programme. That's why I was thrown. But I can go for one.
It's the introduction.
Oh, yes.
64281 and number 4. Well, I've read it once. I won't read it again.
Oh, permitting fees should not reflect.
Yeah. Is that a basic parameter or, frankly, not?
Well, it depends what one means. This whole document is an expression of opinion by the authority about the way in which the polluter pays principle should be operated and other aspects of environmental policy. I'm not sure I would accept that one can be dogmatic about exactly what the permitting fees should reflect, consistent with the policy, provided that the real issue is do they comply with the policy.
Well, that seems to be what the policy, they think the policy means. I mean, the inference is that they've read 5.3 in that sense, maybe wrongly.
Well, yes.
They say certain basic parameters were established. I'm not quite sure whether they mean by someone else or by themselves, but whatever. It does seem that the inspiration is likely to have been 5.3.
You mean 2.3, I think.
Sorry, 2.3. Yes, I mean 2.3. Anyway.
Yes. Well, my Lord, that may be right, but ultimately, I submit that one...
We've got to look at it more
yes,
broadly.
One needs to look more precisely.
Yeah.
One needs to look more broadly at the policy and bear in mind specifically the point I made. I submit that one's looking at that in the context of it being itself guidance as to how the system will operate.
Yes, thank you.
So, my Lord, I was just really trying to think of some examples of the way in which one might interpret the term correcting environmental damage, and it's perhaps easy to assume that it must mean actively going out and reversing environmental damage. And one can imagine that correcting environmental damage could be used as a description, for example, of replanting where an area has become subject to deforestation or dieback in some respect, or it could involve clearing up oil pollution. But it doesn't have to involve those things for it to be properly regarded as correcting environmental damage. After all, if environmental damage is occurring because pollution is being emitted into the sea, for example, and washing up on the beaches, if you stop it being emitted, then in a sense that is correcting environmental damage. And that's an example of the sort of thing that might fall precisely within the remit of the authority when it is simply by virtue of its activities in requiring permitting.
Well, I think we've got that point. I mean, that's your argument in paragraph 43, essentially.
My Lord, I suppose it is, yeah. And we go on, of course, to point out that the cost internalisation aspect of it is dealt with in some extent, to a large extent, by the fact that it's not just the fee, but you've got to bear the costs of putting it right yourself. Right. Can I just take a look to the example that we've got in the evidence of the permits? And I think the Lordship may have looked at this already, but
yes,
this is in Record Volume 1, 269.
Well, 274, isn't it?
So it is. You're quite right. I'm sorry. Yes. Actually, the reason I had the reference of 269, I will go to 269 because it's part of the evidence of Mr. Goddard, who was the manager of technical services at the Environmental Management Agency, explaining in a little more detail the cost associated with implementation of the terms and conditions, and it's paragraph 14 that I want to draw your Lordship's attention to. It's not just some sort of academic point to say, oh, well, these conditions will give rise to cost on the part of the person who is polluting. There are concrete examples given there of the sort of money that one's talking about.
Extraordinarily precise figure for an estimate. Unless he's talking about a particular sand plant. He might be.
Well, I wonder whether he's referring actually to the thing which
Yes.
is exhibited, which I was about to go to.
Yes.
Can I just ask you on page 273 at the top, at this time he wrote this in 2009, only 2 permits had been issued. But he said that 8 are under consideration. And he makes that as a point why we shouldn't quash what else we do. Do we have any information about how many permits have been issued since this? Because presumably the thing's been operated.
My Lord, we don't, but I'm sure we can find out and let your Lordships know through the usual channels if I can assist.
Might be of interest, just considering what the implications would be of
Yes.
any order we might make.
We'll make inquiries
Thank
and
you very
we'll write in with the answer to that question. Obviously, copy the other side in. My Lord, I was going to go to this example of the water pollution permit just to show your Lordship some of the features of it. It starts on page 274. If we go within it to, first of all, 281, we can see that there is provision, I won't go through the detail of it, but there's provision in detail about the permissible levels. You can, I won't, as I say, go through the detail of it, but you can see that in principle, I'm not quite clear myself whether this permit does this, but in principle it would seem perfectly possible for the conditions of the permit to include actually that you reduce the amount of pollution that you emit. So you can start off at a certain level and then go to a lower level later on. That seems to be what's happening as between the two tables, Table 3 and Table 4. And then I wanted to take your Lordship's briefly to 286, where in this permit there are also requirements to adopt what are called best management practices. And there's a requirement to adopt letter A underneath Roman 4, best management practices plan, a best management practices plan. That's a plan that has the objectives of minimizing the number and volume of pollutants generated, etc., etc. And then over at 287 at the bottom of that page, structural BMPs, that's best management plans. The BMP should identify structural components to control, in this case it was stormwater pollution, sediment transport off-site, and surface runoff where practicable. Examples of structural controls include, but are not limited to, various things: road stabilization, construction of temporary gravel entrances, coagulant water treatment in settlement ponds, use of sediment traps, silt fences, floating turbidity barriers to control sediment transport and reduce suspended solids, etc., tree and natural vegetative cover preservation and protection, and so on. So these are examples of very specific things that the recipient of a permit is being required to do as a condition of being allowed to carry on polluting, and makes good, I would submit, the abstract proposition that the effect of the scheme is itself, in some measure, to correct environmental damage. Because presumably, until the time when the system came in, the people who had this permit, or people in a like position, were doing whatever they were doing in their industrial processes, but were not ensuring there was road stabilization or whatever it might be. So, as I say, in my submission, that this is a concrete example of actual correction of environmental damage being required as a condition of the permit being granted. And
Well, that's clearly right, but of course it's not out of monies collected.
It's not directly out of the monies collected, my Lord. No, that goes back to my
Yes.
submission about how closely you read that.
Well, quite.
I say it is in a sense because the monies collected are what enable there to be civil servants who can sit and impose these conditions upon people who want to pollute. In that sense, the monies collected are being used to correct.
Is enable the authority to build up any reserve to cater for continuing pollution or emergencies or anything like that, and that might be said to be the deficiency.
That might be said. That might be said to be a deficiency. In my submission, it shouldn't be said to be a state of affairs which is not in accordance with the policy. I agree. As a matter of policy, if one wanted to change the system in Trinidad and Tobago, one could say that that's how it ought to be done. But in my submission, it's perfectly proper for the Minister and implicitly Parliament, by not exercising its power to strike the regulations down in 2001, to come up with a scheme which doesn't go that far. It may not be a perfect scheme in that respect, but it's not an unlawful one as being not in accordance with the policy in my submission. The last reference to like effect is, that's to say as regards correcting environmental damage, etc., is on 290, paragraph F, duty to mitigate. Permittee shall take all reasonable steps to minimise or prevent any discharge in violation of this permit.
Yep.
As a result, likely to adversely affecting human health or the environment. So, and all that, I think, is what I wanted to say as regards the attack on the scheme as being contrary to the NEP. It's not for those reasons, I respectfully submit. The alternative case, which is advanced by reference to the decision of the Minister, and whether, as I understand the point against me, it's really said, well, that there's no evidence that the Minister considered the recommendation of the authority contained in the programme. No doubt, if your Lordships think that that's a valid point and useful point to consider, your Lordships will do so. I do respectfully note it is not one of the issues that was agreed to be an issue before the Board. If we look at the Statement of Facts and Issues, at paragraph 41, in my submission, that's not really within the scope of the attack as it was set out there, which was put by the appellant in rather broader terms about the principally being about the point I've just been dealing with. I can't. Well, in my submission, on a fair reading of those issues, there's no issue put in play as to whether the court should say that there is unlawfulness because the Minister did not consider the water pollution programme. Evidence of that. But I mean, I accept there are references to it in the Statement of Facts, and there are references
But I mean,
to that in the case.
They can't take the point of.
Well,
I mean, it was certainly in play, right, if you go back to the original grounds, that it just hadn't been considered. I agree, it's sort of, the trouble is with in the judgment below, it sort of gets diverted off into various different ways. But
yes.
It's not far off J in paragraph 41.
well, this is a sort of pleading point.
Well, presumption of regularity, there being no evidence
Yes.
that it was properly...
Yeah.
Yes.
Yeah. I mean, I think I've said what I want to say on the procedural aspects of that. Well, other than to say also if one looks at the case.
Yes, that's quite a
pretty
significant point. That the Court of Appeal was saying, well, in the absence of evidence, specific evidence from the Minister, we must assume a presumption of regularity, which is not, I must say, I found that a little difficult.
Yes. Well, that aspect of it doesn't form really any part of my submissions,
No.
my Lord. But no, I mean, it's also, I would submit, fair to say that the way it's put in the appellant's case is really about the point I've dealt with about the compatibility of the policy with the rules with the policy, rather, which is why the peroration of the case is that you should quash the scheme or quash the decision of the Minister to charge a flat fee as being contrary to NEP. But given that I suspect in reality your Lordships will want to look at the point anyway, can I just conclude by going back to the programme and dealing with the suggestion that the rules are unlawful because there has not been or no evidence of consideration of that programme. My Lord, the programme is at, if your Lordship's got it open in the version we had a few moments ago, it's Authorities Bundle 1, tab, sorry, lost the reference, tab 10.
Yeah.
And just before I go to the bits of it I wanted to draw your Lordship's attention to, it's important in my opinion, before one gets on to considering whether it's appropriate to quash the policy or order the minister at least to reconsider I keep saying policy, quash the rules, or order the minister to reconsider whether the rules should be modified in some way in the light of what's said by the EMA in this document. It's important to consider whether whether there really is a serious contention in play that there's an incompatibility with the policy as in the light of what's said in this document. In other words, what I mean is it's got to be a relevant factor that should have been considered by the minister, and whether it is or not depends upon what is said in the document. In the recommendation of the authority. One might accept that if there were a very clear and specific and well-reasoned recommendation, it might be said to be unlawful not to consider it. But one needs to look at the quality of the recommendation
you can't
before.
say this is not a material consideration, can you? I mean,
well, my Lord...
assuming the minister had a discretion in the matter, a policy programme produced under statute by the responsible authority which deals with this specific point must be material, mustn't it?
Well, can well, one can see why Your Lordship says that in principle the policy is material. Of course, that the document is material. Of course, I see that. But actually, if one looks at the detail and the way it's put, it carries considerably less weight than that.
Oh, yes,
my submission, and one should hesitate to get into.
It's not binding him, but it's nonetheless material consideration. I mean, it's like in planning terms. You have statutory policies, you have informal policies. I mean, they're all material if they're relevant and produced by a responsible authority, but the weight you give them is a matter for the decision.
Well, but of course, I accept that. That's absolutely elementary. But nevertheless, in deciding whether one is going to accept a submission that one should quash some decision for failure to take a material consideration into account, one does need to look fairly closely at what is said to be the material consideration and whether it's realistic to suggest that the decision is unlawful for failure to consider that. That's really all I mean by way of preamble to what I wanted to say about the document itself. And it's simply really to point out the terms in which the matter is put, because it's, in my submission, relatively tentative. Various permit fee models are considered in this document, as we've seen. And the contest, I suppose, is between the existing one, which is Model 2, and what my learned friends say ought to be the correct model, which is Model 6, and let's failure to consider Model 6, which is the criticism. Model 2 is the one which fits in with the evidence, or is consistent with the evidence, as it were, as to what the reason was for choosing the scheme in the first place. This is a simple model that will be easy to administer. That's page... if you're in, it depends which version you're in.
1289.
Yes, 1289. Thank you. Simple model, easy to administer, suffers from several inherent deficiencies, which are then set out.
Well, the last one's quite important, isn't it?
Impact of pollutant on the environment.
Impact takes you straight back to correcting environmental damage.
I suppose yes, it does, yes. Then Model 6...
Speaking for myself, it's the criticism of Model 2, rather than, for that reason in particular, rather than the advocacy of Model 6, which I think you need to meet in seeking to say that the programme didn't really contribute much.
Well, the answer to that, in my submission, is that it doesn't tell you anything that's not already obvious. Model, I mean...
Cuts both ways.
Well, it was a decision... No, but if I'm right about... If I'm right that it doesn't conflict with the policy, then we're into this territory. Obviously, if I'm wrong about that, and your lordships think actually it's in flagrant breach of the policy, then it doesn't really matter whether the minister chose to look at this document or not and act on it, because it's not in accordance. The rules aren't in accordance with the policy, and therefore they're unlawful.
Well, it might operate in that twilight zone where one came to a conclusion that it wasn't a cold question of legal construction of the policy, but a reasonable attempt to gather the spirit of it by a body set up specifically for the purpose, namely the authority.
That's more perhaps a point to do with the Model 6 recommendation than to do with the deficiencies in Model 2, in my submission.
Well, it's because the whole point is here's a serious attempt to look at different ways of doing it, weighing in the various elements which one finds in the policy, and reaching as you say, a tentative conclusion, and it's then simply ignored. I mean, that's the complaint.
Well, taking it in stages, the criticisms of Model 2, I do say that the criticisms of Model 2 are essentially obvious criticisms. I mean, the benefit is that it's easy to administer, but obviously it doesn't distinguish between these various different factors. But that is plain on the face of that was plain on the face of the draft of the 2001 rules that was laid before Parliament. It was there is evidence in relation to that decision, of course, because that's what that's what the then minister addressed in his affidavit, where he said that this was the model that he proposed to adopt because it was appropriate for the stage of development that he perceived there to be in the country.
So don't know whether he had a sort of a previous version of this before him. I mean,
well, I think that's right. Can I just look at that evidence? That's in the same volume that I've got. It's Mr. Mohammed, isn't it? Dr. Mohammed.
He told them to produce a simple model, and they came up with what they did. But
yes, this is for just if we can go back to it very briefly. This is 293 in volume 1 of the record. This is a clear explanation of the reasoning behind the 2001 rules. It's not material that, in fact, somebody else put them into force after he left office, because...
Well, whatever he did or didn't have, he certainly had the 1998 National Environmental Policy. What's he say about that, Mr. Rowe?
I think, my Lord, that's one of those questions that I'm not able to answer, because I don't think he deals with it, does he?
Very well.
But he does say, this is the point I rely on in the present context, he says at paragraph 6, he was of the firm view having regard to the state of economic development and the level of institutional development of the country. And that's quite important, because institutional development is what you need in order to run an elaborate scheme which enables you to charge lots of different sorts of fees. The most appropriate model for WPR, that's in other words for the rules, would be the model that was user-friendly and the simplest to administer. And he gave directions that that was the model to be used. That was the model which went into the...
Model 5, which scores highest on simplicity.
Well, Model 5 is another... Model 5 is more complicated than Model 2, because it does require you to look...
Simplicity 13, egalitarian approach 12.
Well, I wanted to come on to that at the moment, because in my submission that gives a degree of...
But I mean, we're not here to try and
choose
between these
really
models. I don't know quite why you're taking us through this all, because one can read it and one can see that on some aspects they're more tentative than others, but we're not here to review this. The complaint is that it was simply ignored.
Yes. Well, my Lord, I'm taking your Lordship through it because so far as it points out the deficiencies in the system that was actually being used, I say essentially, well, yes, but those were obvious deficiencies that the Minister must have known about when he made the draft rules, and Parliament must have known about when it decided not to negate them. And insofar as it, and this is the part I need to deal with, of course, insofar as it deals with the recommendation positively to adopt the more complicated system, in my submission, it really doesn't come to much. It does, I say, bear so little weight when one looks at it closely. that it is inappropriate, it would be inappropriate to strike down the current scheme or require the minister to consider doing the current scheme simply on the basis of the lack of evidence of having considered all of this. Because, and this is the point I wanted to make about the way in which the authors of this report express themselves. 6423 analysis, it's proposed to assess the merits, demerits of the various permit fee models using the following point scale. And they then have these various figures that are given for cost recovery, equity, simplicity, and punitive. And then they just allocate points to them in the table. And of course, just looking at that, one might think this is a rather sort of scientific way of looking at it. But as they themselves accept underneath, the above analysis is entirely subjective. And it is the authority's expert opinion that Model 6, i.e. the pollution load approach, is perhaps the most equitable and will be used as the basis for determining water pollution fees. And in my submission, it really comes to no more than this, that in 2006, there was a report which made the, in my submission, somewhat self-evident point that there were different ways in which you could do this, and that you could do it by a different method, namely by having a pollution load approach which had various different provisions to it. But in a sense, I say, well, so what? Because that all must have been apparent at the time that the rules themselves were introduced in 2001. And it would be not in all the circumstances, I say, appropriate to revisit the matter in the light of this report. I acknowledge, of course, it comes from an authoritative source, but one has to look at it for what it is. And it's really, in my submission, no more than some musings on the part of the author as to the different virtues of different aspects of the scheme. Perhaps musings is the wrong word to choose, and I'll take it back, but it sounds disrespectful. But I hope your lordships have my point. It's a narrative document which sets out various different sorts of ways you could do it, but none of it was earth-shattering news in 2006, in my submission. Shouldn't have been earth-shattering news. And really, one is concerned, I say, with the principal attack policy. If I'm right that the rules are compatible with the policy, then that's the end of that challenge, and that ought, in my submission, to be the end of the matter. If I'm wrong about that, then they fall for incompatibility with the policy.
Can I just ask you about remedy? Because the valid point is made by Mr. Goddard that it would make much sense to quash something which would throw in doubt the whole basis on which things have been proceeding for the last few years.
Yes.
It possibly mean you had to pay back the money you had already received, which would be slightly curious. I mean, what do you say about remedy if we were to say there was a failure to consider this properly and potentially a breach of the policy? What's the remedy?
Well, it depends how your lordships decided. I suppose if your lordships decide that the rules are contrary to the policy, not in accordance with the policy, then I suppose your lordships will have to say so, and I'm not sure there's any...
Oh, you say so, but it doesn't mean we quash them.
No, you could
There's plenty of precedents for making a declaration.
Well, you have to make a declaration and direct the minister to reconsider what the rules should be. Reconsider exercising the power to make rules.
That wouldn't necessarily have the effect, as long as we made that clear, that it unwound everything that had been going on since the rules were made. No,
well, that's right, and that, in respect, is an important consideration to take into account. Equally, if I persuade your lordships that the rules are not, or that they are in accordance with the policy, and therefore they're lawful in that respect, but nevertheless, your lordships think that the minister ought to have considered the possibility of amending them, not because they were unlawful, but just because they were not optimal, and this was a material consideration in considering that, then that's perhaps more straightforward. You just say, well, go and think again.
Yeah, thank you.
Before I close the programme, Mr. Rowe, could I just ask this? There are several references in the analysis of the models to Wisconsin, which obviously has a rather sophisticated system. Somewhere I've read a statement about consideration of other United States which makes the point that Wisconsin is rather out on a limb.
Yes, that's Mr. Goddard in his affidavit.
It's Goddard's affidavit, is it?
What he doesn't, unfortunately, do is to explain how he came to the recommendation.
No. Forgive me.
Mr. Goddard's
Forgive me, it's not the question that I was asking. The question that I was asking was at what point had that analysis been made?
At what point had the analysis by Mr. Goddard been made?
Yeah.
Lord, I don't know off the top of my head. I shall have to remind myself what Mr. Goddard actually said. Give me a moment, I'll see if I can find it.
I mean, this is discussed by Mr. Raj Kumar in his affidavit in the second bundle at page 391, where the judge has tried to get some information about all this, and he's told that Mr. Goddard has left, and Mr. Raj Kumar doesn't know where the information came from.
Well, I think it may be, to answer, to focus on the rather limited question that I was trying to ask, paragraph 17 of Goddard at page 270. But you tell me if I'm right or wrong, Mr. Rowe, because I might easily be wrong. Top of 271. In which event he's saying that he discovered it at the time of the preparation of the programme, I think.
Yes.
Which is 2005, is that right?
That was the time the programme was being prepared, yes. May I just read it for a moment?
Please.
Yes, that would seem to be right, because he says in the course of the research done on or around the time of the preparation of the programme.
Yes, the problem is that's not consistent with what Mr. Raj Kumar says at page 390 of volume 2, but maybe it doesn't matter. He says in paragraph 4, the research entitled Analysis of Various Permit Fee Models is a subset of an entirely different an entire programme. Responsibility was Dr. Ram Logan. So
Where's that?
that's paragraph 4 on page 390.
Well, there's a long section of the judge's judgment about Dr. Ram Logan.
Yes, indeed. So, and Mr. Goddard has left, so that's left in the air.
Well,
Mr. Raj Kumar, paragraph 6 on 391, otherwise 910, Mr. Rowe,
Yes.
says at sixth line down that the management programme was produced over 12 years ago. And this affidavit was sworn in 2012, rather indicating that the management programme was produced prior to 2000. So it was work in long progress until it was ultimately born and signed off in 2005. Could that be right?
Lord, I suppose it could. What I don't know, and I'm not sure I can help you, Lordship, with, is whether an earlier version of the programme or anything at some earlier stage was available, such as might have fed into the original 2001 rules.
Quite.
As a matter of interest, was Raj Kumar there at any material time, or is he simply the chap who's currently in post?
Was he? I didn't know.
He joined in 1997.
Oh, he did?
Yeah. So he'd been around quite a long time.
Yes, he did. And he worked on the programme, he says, yes. Thank you. Paragraph 3.
Yeah.
Right.
I think your Lordships have my submission, but I can expand if you want me to, but I think that's all I need to say otherwise. Thank you.
Thank you, Marshal. Mr. Hussain.
Just 4 short points, Milan, if I may.
Right.
May I refer you to the 2006 regulations at Electronic Bundle 1071. Specifically to the portion dealing with Rule 17.4 at page 1071. It shows there that in 2006, the 2001 regulations were, first of all, schedule were replaced by this particular schedule, so there's an entire exercise of fresh discussion. But more importantly, for the first time, in respect of Rule 17.4, which deals with a variation under the rules. In other words, when you want to vary a permit because you have gone below the permissible level, there's a range of fees or charges stipulated in 10,000 and 150,000. I'm dealing with the prescribed 3 point. Now, if I may take you to the following page at 72, it says as follows, and it deals with the prescribed 3 point as well. Services for which charges are payable. The Rule 17 include consideration of applications and the use of specialized expertise external to the authority. Charges paid to the authority pursuant to 17.4, which exceeds $10,000 shall require a statement of expenses from the authority identifying the cost items that resulted in the charges exceeded $10,000. So what we have here, first of all, is a range of fees and charges that are payable. Fees and charges are interchangeably. And the placing of a figure here does not necessarily mean the overhaul of the entire regulations. Because here's an example of where an amendment or where a changed fee regime was introduced, which establishes a range on which vests in the authority power to determine where in the range you fall, and an element of accountability to the committee in respect of how it is that the charges are supposed to be provided as statement of expenses. I say that in aid of bringing the issue. My little friend's point about prescribed fee has to one fee as the case may be, and it might require an overhaul of the entire rules regime. In fact,
Could you, Mr. Hussain, try to direct your voice into the microphone, because I think you're moving away from the microphones and we are getting a fluctuating sound. There's a little bit of disturbance now as well, but we'll have to live with that.
okay. Yes, Mr. I apologize.
No, it's not your
Is it
fault.
okay now?
Yes,
Reception?
yes.
Okay. Well, the learned friend made 2 points. The first point he made is that it will require an overhaul of the rules if we are move from the permitted fee, and it might be quite elaborate. And I cited the 2006 regulations at Electronic Bundle, page 1071 and 1072, to demonstrate an example of a range of fees that are chargeable in respect of the variation of permits under Rule 17.4.
Yes,
And in those circumstances, the authority has to account as to how the expenditure is justified. Now, the same thing can be done in respect of an annual permit fee. So it doesn't require an overhaul of the rules. And in any event, the regulations amend the rule. So there it appears to be, by inserting the following regulations, it seems to supplement the rule or change it as the case may be in respect of how charges are going to be allocated. That's one point. The second point is the point my Lord raised in respect of where in the issues is the question of there's no evidence in respect of the exercise of the discretion of the minister. And if you look at the electronic bundle 898, it might be impliedly accommodated in paragraph 41D, which reads, where the Court of Appeal was wrong, whether the Court of Appeal was wrong to defer to the interpretation of the Environmental Management Authority.
So which page are we on?
Not the decision maker. 898.
Yeah.
898.
Paragraph 48. 898. 898 electronic. Oh,
I think this must be.
Case?
Is it a case?
Statement of facts and issues.
Yes, this is the
Yes. Right, we have it.
statement of facts.
it's the last paragraph.
Yes, at D,
Yes.
It might be accommodated here implicitly whether the Court of Appeal was wrong to defer to the interpretation of the EMA when it was not the decision maker and when it had itself otherwise recognized that rectification was a necessary part of the polluter pays principle. It might be on that limb can accommodate the question of whether the decision maker took into consideration the either the policy or the program as the case may be. The final point, my lords, is in respect of the issue of the permit that is annexed to the affidavit of Mr. Goddard at electronic bundle 281.
I thought you had 4 points, Mr. Hussain. But this is the final one.
I think I'm on the third, Millard. Yeah.
Yep.
Okay, Millard.
Good.
This is the permit here, Millard, and what we see is the table on page 281, interim limits for discharge and permissible level in the second schedule of the rules.
Yes.
And if you look at 5, Lords, failure by the permittee to meet the level specified at Part 2A4 will constitute a violation of Rule 20C of the WPR, which may result in the revocation of the permit fee. So therefore, the permit in itself, with respect to the conditions imposed, demonstrate that there is a real possibility of violation. Even in a situation where you have to reduce permissible levels of pollutants, there's a real possibility of violation, and that it is that band, that range, mediation is supposed to correct, either over a short period, over a long period, as the case may be. And unless there are other questions, my Lord, those are my submissions in answer.
My Lord, Lord Carnworth has one question more to put, in fact, to Mr. Rowe, but you'll have a chance to reply, Mr. Hussain.
Well, Mr. Rowe, I just, maybe you'll be able to clarify or maybe not. Page 1071, Mr. Hussain referred us to the amendment regulations.
Sorry, which volume is that I'm working on?
It's the volume 1, page 1071, under tab
Authorities one.
Sorry.
Yeah, 1071.
And where he drew our attention, I think for the first time, to Rule 17.4, where the application for a variation of a permit can be $10,000 but not exceeding $150,000. And that took me slightly by surprise, because if one compares that with the previous version at 1095, under tab 6, there was simply a figure of 4,000 for variation of a permit. And I'm trying to understand how you could have a sort of variable rate from 10,000 to 150,000 and how that is assessed, because it rather sort of goes against your idea that they have to be prescribed specifically.
Yes, well, 17.4,
I mean, I had a look, that's
that's
in
at
the rules,
1086 in the rules.
but that doesn't seem to tell you anything much about it. But I mean, if you can't answer it now, maybe you could take some instructions.
Yes.
You know,
I think rather than attempt an answer on my feet,
well, I
I
think
shall
it's
take
better
instructions.
on its face, it looks as if there is a sort of measure of discretion, presumably related to the scale of what's being undertaken. But it's not very easy to see why that should apply to a variation and not to the application. But anyway, if you can throw any light on that, I'd be grateful.
Of course.
The board is grateful to council on both sides for their submissions in writing and orally, and hopes that the experiment which we've just conducted, which we hope to continue, has not proved too difficult. I think informally any feedback would be welcome, and certainly there are no doubt technical improvements which might be made. But thank you for cooperating, and we hope that it is a fruitful development for the Judicial Committee to have encouraged. The board, having said that, will take time to consider their judgment, which will be handed down in the usual way. The court is now adjourned.